Oh, hopefully I've unmuted myself. All right, so I'm just going to start by introducing myself, and hopefully Emma will share my presentation in a moment. So my name's Angharad Price. I'm quite new to the Equality and Human Rights Commission. I started last September, and I'm in a new role, Legal Principal Wales, so I'm their specific Welsh lawyer, because although the Commission is a GB body, so we cover England, Scotland and Wales, they recognise that we need Welsh legal expertise with the rising devolution. Just a bit of background, I'm sure most of you know, but the Equality and Human Rights Commission is the regulator for the Equality Act and also an A-grade UN human rights institution. So that means we, as you know, have legal responsibilities in terms of the Equality Act, monitoring and unique enforcement powers to enforce the Equality Act. And we also report to the UN about the UK's and also Wales's progress in terms of UN treaties and human rights obligations. And I'm sure if you want more details afterwards, you can contact me, or you can look on our Twitter at EHRC. So one of the reasons we sort of arranged this event with Legal News and with Emma was because we, over the last year, used one of our unique enforcement powers, which is to conduct an inquiry to collect evidence in relation to disabled defendants in the criminal justice system. So one of the things identified in our previous research to that was that there's a high proportion of disabled defendants in the criminal justice system, and they experience barriers. And one of the specific barriers was about video hearings. So there was a focus in that report, in that inquiry, in the criminal justice system, just because video hearings, video links for criminal hearings is what had been identified, and also a higher proportion of disabled defendants. I don't know if Emma can just share my presentation at the moment, because I'll just run through some points with you. I'm not going to talk very long, but I just thought it'd be worth setting the scene in terms of our inquiry report before we talk further about video hearings and some of our speakers talk about their own experience. So it's on our website, Inclusive Justice, a System Designed for All, because one of the purposes of the inquiry was about how the criminal justice system could be designed better for disabled defendants. You can flick on, Emma, to the next slide. So our full report hasn't been released yet, but the Commission has released an interim report about video hearings because of the swift expansion by the Ministry of Justice and the use of video hearings during the current crisis. And I'm sure you're all aware of the immense increase in the use of video hearings, not just in the criminal justice system, but also across all of the justice system in all of the different jurisdictions. Our interim report highlights how the use of video links impacts disabled people and the findings of our inquiry on the basis of that, and also makes recommendations to the UK government about how they can mitigate those impacts. If you want to flick on to the next slide, Emma. So just a bit of legal background. One of the reasons we were protecting that right, most of you are probably aware that access to justice is one of our priority aims. But also, specifically, we're concerned about Article 6 and the right to a fair trial and the implications for disabled defendants if they weren't able to participate in video hearings. Obviously, the Equality Act and the duty to make reasonable adjustments. And also, we're aware of the Equal Treatment Bench book, and the inquiry picks out obviously sections of that judges, when they're making decisions about whether how hearings should go ahead, how they should consider the impact on disabled people. And each of the jurisdictions have their own various procedural rules and judicial guidance. And I'm sure many of you are aware that during the current crisis, they've all got temporary interim guidance to help support them. And one of the overriding things within our inquiry report is to highlight to UK government, and particularly Ministry of Justice and the Court Service, about their obligation when they're designing the system, or when they're amending and changing their policies and services at the moment, that they have to consider the public sector equality duty. You can flick onto the next slide. You'll be grateful to know I've only got a couple more slides to go. So our inquiry focused in particular on people with cognitive impairments, mental health conditions and neurodiverse conditions. Because of the particular ways that can affect them. I'm not going to read out the full list there, but most of you will be aware that those things, particularly things like short attention span, memory loss, difficulty retaining information, anxiety, etc., the impact that can have on someone who's either a party or a witness in hearings is obviously very difficult in terms of their participation. If you go on to the next slide, Emma. So a couple of the really important findings in our report about effective participation are that there is a big focus in terms of self-identification of impairments, and that is inherently problematic. Basically, it means that most of the time people's additional needs are not being even identified in the first place. It's not sufficient effectively simply to ask people if they need adjustments or if they're having difficulties, because they may not even realise that themselves. And then the second very important point is that video hearings can significantly impede communication and understanding for disabled people, particularly with certain impairments, such as learning disabilities and certain mental health conditions. So those are the really two important findings to share from our report. Obviously, you'll all be aware that the decision as to how hearings are conducted are made by the judge or magistrate or panel. And although HMCTS have confirmed reasonable adjustments will be made, they place a great emphasis upon self-identification. So what we found is inherently problematic is effectively their way of asking, people must ask for adjustments to be made. And also they give no specific information about what adjustments might be available. We've got a quote in our report there, which is about, it's a lot more difficult for courts to identify if someone's confused, unable to pay attention, etc., when they're on a remote or video hearing, and it's much harder for them to represent themselves. That quote comes from Liaison on Diversion, a specific service in England to identify where people have difficulties and what adjustments might be made. And you'll see the quote there. They just say you're obviously less present when you're on video. I'm conscious today it feels like I'm speaking to an empty room, and it's obviously much more difficult for certain disabled people. You can go on to the next slide. Okay, so I'm almost at the end. Effectively, our report gives recommendations for UK government, but there are also suggestions, for legal professionals, that you need to try and identify if someone, a party or a witness, needs reasonable adjustments, not just by asking them, but looking for signs that they're having difficulties, ask for those adjustments to be made, and tell us or others if you're having difficulty getting those adjustments being made. And I'm about to pass over to some other speakers in a moment for people to share their experience and our questions and answers in a minute, but that's partly because our interim report, our evidence was collected obviously prior to the current crisis, and so many of the if you like, suggested adjustments there are that instead of using video links for criminal justice, face-to-face hearings are had instead. People are produced to court in criminal hearings, and we're conscious that at the moment that's not really an option. We don't know what will happen as we move out of the complete lockdown, etc. But it's unlikely that we'll be getting traditional face-to-face hearings potentially for some time. So hopefully some of our speakers will talk about their experiences with video hearings, how things are going. I'm sure all of us are struggling in some ways with how things work. But I suppose the message from the Equality and Human Rights Commission is to try and think about how it can be even more difficult for disabled witnesses, parties, etc. And if anyone has any experiences of adjustments that have been useful, we'd be really keen to hear those. And you'll probably also be aware the Civil Justice Council is conducting consultation at the moment, and you can feed back to them as well about how things are going and what could be improved, what other things could be useful. So without me going on for much further, I'm going to ask Michael Imperato to talk a little bit about his experiences of video hearings, etc.
Okay, so yes, hope I've unmuted myself. Yeah, yes. Right, I'm going to try and share my screen. Got a little short PowerPoint here. Right, so here we go. So try to give a kind of a practical viewpoint on some of this from first-hand experiences. I mean, what we can say is that certainly the lockdown has spurred us into action, and it will revolutionise systems as we know it. We ought to be open-minded, recognise that days of resistance is futile, as they say in the movies, and some proceedings may be transformed entirely forever. A necessary assembly at court will be consigned to history. There's obviously virtual hearings that will save time and money, but is this still a sticking plaster, or is it the phrase the new normal? The answers will depend maybe not really on the technology, but where we choose to draw the line about what is a good use of virtual technology and when it is a bad use of technology. So stories from the trenches, as I call it, and I think in my experience, the group of people who've really been thrown into this is some of the family lawyers, the care lawyers, who have traditionally dealt with things quite usually by everyone pitching up at hearings, and you have parents and guardians and the like, and social workers, and everyone's in front of the judge, and the judge can see what's going on. And they've had to rapidly gear up into this straight away. And of course, some of their stuff is highly urgent and sensitive. So this is quotes from some family lawyers that have spoken to me, talking about the problem with getting their clients to join the hearing. And of course, we have these, the digital difficulties of people, particularly people from less advantaged backgrounds, where they don't have the technical abilities or they don't have the technical resources. And the example there where the lawyer's on the video hearing and the client is on loudspeaker on his or her telephone just listening. So it all gets a bit fraught and a bit threadbare. And again, these are direct quotes from people, particularly family care lawyers. It's particularly challenging for vulnerable and low and clients who need the support of an advocate. It's difficult to check their understanding unless they're sitting next to you. If they're remote as well, to check their understanding of what's going on. We try to address it by the use of pre and post hearing discussions with the client, but they're not getting that direct support and that direct input into the hearing. So looking at the technology, well, it seems to me that the courts are very keen on Skype for Business, and I say what could possibly go wrong. There's obviously a lot of discussion about the safety of things like Zoom and stuff like that, but Skype for Business seems to be the one of choice in my experience. I talk about virtual etiquette, and that's an interesting thing which I think is also part of what we're doing today and what's happening in people's offices, in that they're having these Zoom meetings. And so are we going to have to develop an etiquette of when you say something, when you are quiet, when you mute, when you don't mute? That's the kind of thing which I don't think anyone's really been thinking about too much in the court context. There's a communication barrier. I mean, that is the problem of, how do you communicate with your client? And the passing of virtual notes. And I think all of us who've been in courts will have had that time where you have that tap on the shoulder from your client sitting behind you, who then tells you that you're talking a load of rubbish, or that something's totally wrong, or is giving you something very useful pointer. Now, how do you have that? And of course, how do you get the other way around, where you need to well, again, in the court, you turn around and say to your client, "Oh, could you clarify that, or is that right or wrong?" Well, the virtual note issue, I think, is actually quite important, and something which really is a key part of any case. However, as Gloria Gaynor said in 1979, I think we will try and survive. And I'm old enough to remember back in 1999 when there was the change to telephone hearings, and that was revolutionary in its day. It saw the kind of death of the agent solicitor. When I was a very young solicitor, an article clerk, we used to spend a lot of time going to the local court on behalf of other solicitors in other parts of the country. But it was brought in then the idea of the telephone hearing, which we're all now very familiar with. It was used primarily for procedural skirmishes, as I call it. It's lawyer against lawyer with a district judge on the end of the phone. And we learned to adapt to that. There was a much more about filing stuff in advance, trying to narrow issues beforehand with your opponent, not expect papers on the court file to be in front of the judge, that important lesson. And I'll just say that we will have to do the same again. It will be a learning curve, but lawyers, particularly lawyers who do a lot of legal aid and lawyers who work a lot with the clients, they're very flexible, very quick to learn, and have had to adapt an awful lot in the last few years. So I think the new normal will not be normal. Some change was overdue. I think there is a need to kind of bring us into the 21st century. Public lawyers, and this touches on what Ang Harrod was saying, public law lawyers know that change in haste normally does have flaws in it. And the fault lines are usually in respect of the vulnerable. That's where, you know, that's where often in the haste to kind of get something up and running, the decision maker has not looked into that enough. So the challenge for various sectors, and I think the courts, for our health services, for education, and this is very relevant in health, where GPs have all of a sudden adopted triage and virtual meetings and telephones, whereas for many years, you know, some of them were quite resistant to that. I mean, others are very keen on it, but it's been a big change in all areas of our public life. And what the challenge now is to try and capture the good, the things that have been turbocharged change over the last 2 months, to capture the good, but keep the safety nets for where it's not going to work. So the evaluation, in my view, and again, Anghara touched on this, the key is evaluation, feedback, and outcomes, and it needs to be public led. It shouldn't, you know, these are public services, and so we need to bear in mind what the actual member of the public thinks of all this, not for the convenience wholly of lawyers. Okay, so I hope that's helpful for everybody. Try and stop sharing now. There we go. There we go. Hold on. So is everybody back to normal now? Yes. Yeah.
Great. And thanks for that, Michael. Michael Impratu from Watkins and Gun Solicitors there. I think most of you know him, but I should have fully introduced him. Apologies for that. Now we're going to hear from David Gardner of Number 5 Chambers. He's going to speak a bit about conducting video hearings for us.
Well, good afternoon, everybody. I'll start with a very quick thanks and a very quick apology. My quick thanks is to Anghara and Emma, and to the Equality and Human Rights Commission and Legal News for putting a conference such as this on. It's really incredibly important for people to be able to share experiences, especially when we're perhaps not meeting in person quite as much as we were. My apologies, and is because of my lockdown hair, which you can probably see there. It's what my wife calls a stage 4, and we've never got to a stage 6. So I'm going to be slightly above, so you can't see too much of it. Right, so my practice is, in essence, judicial review and court of protection. Those are the largest areas of my practice, which means that the majority of what I'm dealing with is firstly, of course, civil rather than criminal. And secondly, is largely to do with mental health, mental capacity, and community care. To that end, I'll in a moment speak a little bit about some perhaps practical experiences I've had, and indeed maybe some good practice. I did want to try and assist somewhat with the law and highlight a case that's recently come out of the Court of Appeal. It's in relation to family proceedings, but some of the guidance I think is probably useful for everybody, and can probably be applied to anybody who's considering remote hearings. The cases are Re A and Re B. The citation, if it assists, is 2020 EWCA CIV 583 and 584. So that's 2020 EWCA CIV 583 and 584. And in that guidance, as I say, applying to family proceedings rather than anything else, the Court of Appeal quite helpfully sets out some of the principles to be applied when we're dealing with remote hearings. The first thing that I'll say, and it's not a huge surprise to anybody, is the Court of Appeal does confirm this is a case management issue. It's ultimately for the judge to decide whether a remote hearing takes place, but of course it's important that the parties feed into that as soon as they possibly can. It's going to be a brave judge, I think, who goes against all parties saying a remote hearing isn't appropriate in this case, for example. So that's one of the things that the Court of Appeal says. The Court of Appeal then kind of sets out 10 factors that the parties in the court may want to take into account. I think it's important to have a look at those in greater detail if you're going to be involved in a remote hearing, or if you're questioning whether it's appropriate to hold a remote hearing. I'll really quickly shoot through them because I'm aware of my own time limit. The first that the Court of Appeal highlights is the importance of the issue. So there's obviously going to be a difference between interim orders being sought and final orders being sought. The Court of Appeal looks into whether there's a special need for urgency in a particular case. I mean, certainly in the field of practice that I practice in court of protection and judicial review, there often is, but not always. So it's important, I think, to weigh that up. Is this a matter where your client would be best represented with a waiting for when we get out of the lockdown situation and perhaps people can be in court? Whether they are legally represented, that of course assists, but isn't going to be the be all and end all in my view. It's important that everyone gets the chance to participate in their own hearings as much as they want to be able to do so. The ability of lay parties to engage, so as Michael rightly points out earlier, that there is going to be issues with even access to the technology, which may indicate that actually perhaps a remote hearing isn't an appropriate thing to be taking place. And that needs to be highlighted to the court as soon as possible. Is evidence going to be required? I mean, in a lot of judicial review cases, you're dealing simply with submissions, and it may be appropriate that you to do this by remote hearing. I've done a number. But if oral evidence is going to be required in particular, then there may be a suggestion that do you need to wait and deal with this in a better environment? As I say, it's a balancing act. How long is the hearing going to be? Hearings going over days are happening. So it's not to say that necessarily a 5-day hearing shouldn't be done remotely, but it perhaps weighs against it than if you were to do, say, an hour-long hearing. The availability of the suitable technology. So you need to know what your client needs in terms of being able to access a hearing remotely, and is it available? It seems like an obvious point really, but they may not have access to the technology that they actually need to fully participate. The experience, I quite like this one, the experience and confidence of the court. So that there may be some judges who aren't particularly happy with dealing with remote hearings via Skype business or something along those lines. So better that a hearing is done fairly rather than bulldoze through, as it were, but also of users, of course. So everybody needs to be confident using the technology. And then an important one that I don't think often people are taking into account is the availability of safe potential alternatives. The Court of Appeal specifically recognises that there may be different ways of doing this. So it may be that some parties attend in court and some parties don't. Maybe that simply your client goes to court. I can't say that necessarily be particularly a good thing. It's case specific, I think, is the point. And it's all about advocates and really being on the ball in advance and knowing what your client needs to fully and best access a hearing. So I've gone through that as well quickly, but perhaps a little bit too slowly for my time slot. But I thought reference to that case would be useful for everybody. In terms of my own experiences, certainly my experience is actually that in these remote hearings, clients a lot of the time aren't attending. Certainly for your directions hearings that I'm getting more of than say your final orders at the moment. And certainly those with mental health difficulties aren't necessarily attending. I'd say I've dealt with more court of protection and judicial review cases without the protected party or the client present than I have where they are present by some way. I mean, that's not necessarily an indicator of a system not working. I will say that. It's entirely in civil proceedings, the choice of the client/strict protected party as to whether they want to be there or not. I mean, I've heard anecdotally of a case where one of my colleagues was asked their client if they wanted to attend, and they were simply quite told no, they thought it would be boring. So you can't blame them. Maybe they find the case boring and they don't want to be there. That's absolutely fine. And I say court of protection proceedings in particular before lockdown, a lot of the time protected parties didn't want to attend or something along those lines. So it's not necessarily an indicator of a system not working, but I will say my experience is that seldom are persons with mental health difficulties attending these hearings. Not to say that they aren't, but seldom they are. But what I will say is the reports that certainly speaking to others and my experiences is that where protected parties and clients want to attend, actually a lot is being done to make sure they can attend. I've heard more good stories than I've heard bad stories. Certainly the key is going to be preparation. It's those cases where it's thought of last minute and really people haven't thought how to facilitate the client attending that are really showing to be the cases where it's not working very well. So the takeaway lesson to really drill it down is prep is going to be key for anybody when you're going to be conducting a remote hearing with a client with mental health difficulties. And really, I suppose I wanted to just kind of finish off with 5 key points that I've taken away from dealing with these issues. The first, as you'll probably guess, is speak to the client well in advance of the hearing, and try and identify from them informally what they would want from the hearing. But as Angharad said earlier, just generally knowing their background, you'll be able to, having viewed their files, identify whether you can suggest something that might assist them as well. So it's about getting involved in speaking and thinking about this early. The second thing is support at the other end as well. It's if you've got a client in a care home, carers, I think, are becoming more and more adept at this type of thing. They're being more and more supportive. But it may well be family members. But I think it's important to make sure that you know that the support is going to be there on the other end. I would suggest as well, test the tech in advance. Generally a good idea, but if your client is going to be attending by Skype Business, make sure that they have access to it, that they've seen it being used before, that the carers or family members, the support, they're able to use it as well. I would then also have a conference in advance. Those cases where that's happened, I think, has been useful. It allows clients to kind of understand how this technology works if they've never used it before. You can run through the procedure for them, and you can do it face to face, which is much, much better. And also it kind of incorporates that test element. And lastly, I would say have in place a kind of system, as again, drawing on something from what Michael said earlier, having in place a system that you can get feedback. So make sure that your solicitor can speak to you by WhatsApp or whatever. Make sure that client can speak to you and or solicitor by some kind of system. And again, it's going to be case specific as to what's actually needed. But a system where a carer or client can say, actually, the tech's not working, or I don't understand what's going on, or even actually, I want to leave now. This is. I thought it'd be interesting, but this is now boring me. So just have that system in place. And as a final point, I suppose, that's my experience looking at what the hearings I've been involved in and speaking to others. But I also think it's important not just to dwell on the potential inadequacies of remote hearings. I have my concerns, but I think we're doing the best we can in the situation we are in. But it's what we can learn going forward. My experience has been that seldom have protected parties in the court of protection or clients in judicial review been able to attend by way of video link when there's a hearing going on. Now, it may well be that someone's in a care home, for example, and is unable to access a court. We need to learn from this. We know this technology now works. So in the future, if they can't attend, they're in a care home, they can't attend the potential hearing, why aren't we looking into the idea of them attending via Skype, via some other remote access? So I think if I end on a high, as it were, we might be able to take something away from this lockdown situation and say we can actually improve access to justice with our learning here by allowing people who wouldn't normally be able to attend court an option of attending court. So I hope a few lessons, steal from Michael's phrase, something from the trenches, but also hopefully something positive going forward. As I say, I'm happy to take questions at the end. So thank you very much for having me.
Thanks, David. Thank you. I mean, that is something that we pick up on our report, that for certain disabled witnesses, parties, etc., video hearings might be an adjustment that they need to have. Obviously, the things I talked about are where there are barriers and difficulties. I'm really grateful that Paul Hopkins QC has been able to join us. He's going to speak next. I know he's actually in the middle of a current, I think, video hearing. So I'm really grateful that he's been able to join us in the middle of that. So I'll let him speak now.
Yes, thank you, Angharad. Can I check? Can you hear me? Great. All right. Yes, Angharad's right. I'm currently on day 8 of a remote hearing in front of Mr. Justice Francis. I'm a family practitioner. In fact, it's day 20-something of the case. We'd got up to about day 18 before lockdown, and the judge now is continuing with the lay evidence remotely. I say remotely, it's a bit of a hybrid, actually, if I can explain the situation. We've got a number of parties in the case with intellectual limitations or mental health issues, with the result that the official solicitor acts for one of the relevant parties. The official solicitor did act for the mother until relatively recently, but she's just regained her capacity. The situation is that without obviously going into details, the mother is given evidence. She no longer has the official solicitor acting for her, but she does have the benefit of an intermediary. And the hybrid nature of the hearing is this, that the mother, along with a representative from her solicitors and her intermediary, are all physically present in the Cardiff Civil and Family Justice Centre in arrangements which are consistent with government guidance. So they're in a large room and are apart. The witness is using the hard copy court bundle, which was previously available earlier on at earlier stages in the case. And she is wearing, whoever's come into contact with the bundle is using gloves to turn up the relevant pages. And then the judge is joining remotely, as are all counsel and solicitors. So we have about 30 remote participants because there are many, many parties in the case. I have to say, actually, it has worked relatively well in the sense that we got through it. There's just one afternoon session to go. A few points immediately emerged, though, from the experience from this case. It has taken much, much longer, probably at least twice as long as ordinarily would have been the case. And in one sense, there's no obvious reason why, because in many ways, of course, cross-examining the mother is akin to cross-examining her from the VW suite in court. It's very similar from an advocate's perspective to cross-examining somebody across the video link. But it's a combination of circumstances. We have technical issues cropping up from time to time, people having issues with their sound and vision and so on. There's an indefinable reason why the whole process is taking so much longer. And there are potential implications, I suppose, in that if the cross-examination goes on for so long, when does it become just unacceptably long? This particular case perhaps is an exceptional one, but I suspect the potential for delay being caused is likely to arise in most cases. So, but we're getting there in relation to this one particular witness. In relation to the other lay parties and witnesses who are about to give evidence, there was a legal argument as to whether this should happen at all. And in fact, for a combination of reasons specific to the case, there was agreement across the board, save for in relation to one of the fathers. His counsel objected. And the judge dealt with it in this way, that he was going to proceed to take evidence from witnesses and parties who were happy to do so remotely, but wasn't going to force and compel somebody to give evidence. The position has actually evolved a little. There was also opposition on behalf of one of the grandparents in the case, because she has a combination of health issues, is effectively experiencing huge mobility problems, is self-isolating with enormous cares and isn't even at home at all. And at one stage, and she's also a lady in her 50s, is not particularly computer savvy, and the only way she could have joined would have been by telephone, and the judge accepted that would not have been suitable. But in fact, in the course of the hearing, her solicitors and counsel made strenuous efforts, and they've now been able to establish a Skype link for her, and that is now the plan. So whilst he was certainly alive to the limitations that would have associated with her evidence over the telephone, it wouldn't have allowed that to happen, and obviously wasn't going to compel the lady to come to court. In fact, progress has been made, so it may well be we will take evidence from her remotely as well. There are other practical issues that crop up, obviously in terms of the bundle. In relation to the evidence that we're hearing at the moment, it isn't a problem because the witness has access to the hard copy court bundle. But in relation to other witnesses who will be given evidence from their home, specific bespoke arrangements have had to be made. We were meant to hear from a witness today, not a party, so the local authority for whom I act have to be very careful in terms of maintaining the integrity of the bundle. She wasn't able to cope with an electronic bundle, So therefore, we had arranged for a courier to take just what was required for cross-examination purposes in a loose leaf file to her home, and then with arrangements for a courier to collect it at the end of her evidence as well. Now, for reasons I won't go into, she's not given evidence today. But that sort of arrangement is going to have to be replicated for other witnesses as well. So there's a degree of complication in terms of the practical arrangements that come into play to allow people to give evidence remotely. The other concern, I've had one or two hearings conducted via Zoom. There's also been the concern about the integrity of Zoom. We're using Business for Skype for the case I'm in the middle of at the moment, so it's not arising in relation to this hearing, but potential difficulties in terms of people intervening in the case or it being recorded, etc., have been raised in other cases. My experience in a very exceptional case, it was always exceptional even before lockdown, is that it's possible for lay witnesses to give evidence. There are lessons, I think, to be learned as we go through this, but it is certainly doable. And I've just picked up at the end of David's contribution there. I think certainly there are potential positives to be drawn from this. If in the future it's going to be easier for witnesses and parties to participate from their home, then that's undoubtedly going to be, I think, a good thing. I've also, just very briefly, had a number of directions hearings. They have all, without exception, actually gone very smoothly indeed. And I have no doubt that the experience that we've had over the last 6 weeks or so, lost track of the time like everybody else, but it feels like a lifetime, will undoubtedly hugely accelerate the technological revolution that, of course, Lord Thomas was in the vanguard of in recent past. It is, I have no doubt, we're going to go forward leaps and bounds now and find ourselves in a situation that he had in mind much sooner than perhaps we all expected. So that's my professional experience so far. I'd never heard of Zoom until 6 weeks ago. Certainly know more about it now than I did then. So there we are. I hope that assists.
Thank you. That's really helpful, and such a detailed description of a hearing is really useful, because I think most of us, it's hard to imagine how you would carry on with such a complicated hearing in these circumstances, and it's really interesting to hear that that's actually how things have been managed. I'm going to introduce our last speaker, Rhys Davis. Sorry, you've been waiting really patiently for everyone else. He's from 9 Park Place, the same as Paul Hopkins, QC, who just spoke, and he's just going to speak a bit about his experiences as well.
Thanks, Howard. Can everybody hear me? Can I firstly just echo David's thanks to the Equality and Human Rights Commission and Legal News for putting on the event. The practical experiences that I've had in recent weeks and months with remote hearings are exclusively, essentially, family law related, both in the private law sphere of contact, resident disputes, and then obviously in care proceedings, public law proceedings as well. Michael sort of alluded to in his talk, obviously, the prevalence of telephone hearings. And certainly in my experience, it seems to be that a lot of hearings are still being conducted by telephone. It seems, certainly to anybody who's looked at a court list recently, that certainly magistrate level cases and district judge level cases are still predominantly being conducted on the telephone. A couple of points that have cropped up with some regularity in hearings I've been involved in, particularly where you have a litigant person on the other side, or indeed anybody who is a litigant person and vulnerable on the other side, as David alluded to, is getting those people to engage in the proceedings and dial in. I've noticed in the last few weeks that the courts are expecting the legally represented parties to be a lot more proactive in trying to engage somebody who is in person before the hearing. Because invariably, if you dial into the hearing and the other person is not in attendance, you'll be asked why and what steps certainly my instructing solicitors have taken to try and engage that person. So as David alluded to in terms of prepping in advance, I think putting your instructing solicitor, or if you're conducting the case yourself, on notice that they will perhaps need to take steps to try and speak to a person on the other side to make sure they participate is something quite important, it seems to me. The other problem that's cropped up on a few occasions is with electronic bundles, and again, litigants in person not having access to the papers. It may seem like a bit of an obvious point, but I've been asked on a few occasions if e-bundles have been emailed to a litigant in person on the other side, and it's cropped up on a few occasions that people instructing me don't have an email address for somebody on the other side, that usually only have a correspondence address. So again, it may seem like a bit of an obvious point, but making sure you have a working email address before any hearings so a litigant in person can have papers well in advance seems to be a key point. The other points that have cropped up in remote hearings that I dealt with, really in the area of care proceedings, relate to parties who have low IQ, cognitive difficulties, that sort of thing, and the instruction of intermediaries and advocates to assist them. Generally speaking, it seems to have worked quite well in the cases that I've been involved in, provided obviously the advocate or the intermediary can conduct their assessment or interview of a particular party on a remote basis. On a few occasions, I've had hearings where a particular intermediary has been mooted, and they don't actually work on a remote basis, and we need to conduct a face-to-face interview or assessment. So doing a bit of homework in terms of who the particular person is and how they would conduct an assessment seems to be quite an important point. One of the issues that I have also noticed cropping up is perhaps the tendency of the court to adjourn cases where a final hearing is approaching, and one of the parties has cognitive difficulties, and we need an advocate or an intermediary, which I think was one of the points noted in the interim report the Commission put out recently, that if it does look like there's going to be some difficulty with someone with cognitive difficulties to give evidence in a remote fashion, then there should be a push, certainly, for the hearings to be adjourned. So happily, it does seem to me that is happening. And I think those points also really relate to the instruction of experts as well, in any particular capacity, that again, it may seem like a bit of an obvious point, but making sure that you speak to the expert in advance and making sure they can conduct an assessment on a remote basis, and they don't need to physically see a particular person face to face, again, seems like an appropriate way forward. I've certainly encountered a couple of instances where a particular expert, in one example, a psychologist, was suggested doing an assessment for a party, and nobody had thought to ask if they could in fact do the assessment on a remote basis, so that went out the window pretty quickly. So again, I think it really comes back to the point David made on a couple of occasions, that I think it's doing your homework, making sure the proposed format of the hearing can take place, and more importantly, if you have somebody on the other side who is a litigant in person, that you've made steps in advance to try and engage them in the process. The other thing that I've found quite helpful in terms of taking instructions in hearings, because as Michael mentioned in his talk, the tap on the shoulder has sort of gone out the window at the moment. Having a client's mobile number or email address so that you can receive updated instructions as the hearing goes on, seems to me that's probably about as best as we can do in the current climate. But making sure you have their details well in advance is certainly the way forward. And in terms of concluding point, David's mentioned REA, which was the decision of the President of the Family Division that came out last week, and he's obviously mentioned the 10 factors that the President alluded to in paragraph 9. But regardless, I think whether you do family work or work in other areas, it certainly is worth a read, because it's very comprehensive and gives a very good framework of the factors the court would be applying in terms of determining whether or not a remote hearing should take place. So yeah, those were the points that have cropped up with some regularity in hearings I've done in recent times. So I'll hand back over to Angharad. Thanks.
That's great, thank you. Just before we move on to questions, I just wanted to explain one of the, a theme that's come across from all of our speakers really is that in terms of video remote hearings, telephone hearings, etc., and or taking instructions remotely, that a lot more time is needed for legal professionals. So one of the points we make in our interim report, and also we're recently making in response to UK government inquiries, etc., is about the implications for legal professionals. I know Law Society and Bar Council, I can see Richard is here, are making similar points, particularly in terms of legal aid practitioners. The implications for things taking a lot longer has obviously implications for legal professionals. And you know, we've previously done a legal aid inquiry where we expressed concerns about those issues. I'm sure they're things that you'll all be raising alongside us, but almost all of our speakers talked about, you know, extra preparation time, extra time taking instructions, needs for communication. Paul talked about longer time for the hearings, and all of that has, you know, significant implications for all legal professionals, particularly legal aid professionals, in how those systems operate. So I think Em is going to operate the questions and answers for us now. So I'll hand over to her. But thank you all. Our speakers have all been really helpful. David and Rhys are some of our Equality and Human Rights Commission panel counsel in Wales, always happy to help out. And our other speakers, I'd just like to thank you for those contributions, which I'm sure are really helpful.
Thank you. If anyone has a question, feel free to unmute yourself or wave your hand if you're having problems. Peter?
I was going to ask Paul Hopkins a question really about the taking of oaths by witnesses as to if a witness is taking part in a hearing remotely, how do you manage to get a testament or indeed any other holy book of whatever religious persuasion to somebody to ensure that you get an oath taken?
Well, in the case that I'm dealing with, of course, the witness is at court, so it was the standard procedure. From recollection, she took an oath. There is a shortened version, which I think Mr. Justice Mostyn has come up with, which Mr. Justice Francis says he also implements, which doesn't involve the presence of the Holy Book at all. So it's, I can't remember the precise explicated version, but it's just essentially promising to tell the truth. And those two judges are proceeding in that way.
Thank you. Thank you, Paul. Does time permit? Because if it does, I've got a very short contribution to give by way of further feedback, Emma.
Yeah, please go ahead.
My experience to date has been quite a bit of work being done remotely by way of hearings and so forth. And can I just share for the moment, I'm preparing for a 5-day trial that should have taken place in London in June, where we have 5 experts. There will be 3 parties, 3 leading counsel, 3 junior counsel, 3 sets of lawyers, lay witnesses, to include translators and so forth. In advance of all of that, we have a joint settlement meeting where there will be 3 parties taking part from 9 sites and so on. And with a bit of cooperation from all sides, which is happening, both of those, I hope that the trial won't happen because the case may well settle at the joint settlement meeting, but with a bit of cooperation from all sides, which is clearly happening, both from within the defendant camp and from the claimant's camp, all of that is happening. I've also had the opportunity of sitting and chairing 2 solicitors' disciplinary hearing tribunal hearings, A directions and also the full hearing when witnesses gave evidence and so forth. And I also sat in quite a few hearings as a deputy district judge in the last few weeks. My experience has been that everything has gone swimmingly well. The only problems that do arise, which I think have been touched upon already by others, is when you have a litigant in person who comes ill-equipped to take part in a hearing. Having said all of that, if your litigant in person does not have access to either an iPhone or an iPad, a tablet, or a laptop or whatever, it's been my experience in the past that it's not all that bad, because when litigants in person turn up at a hearing, whether it's a small claim hearing or otherwise in court, they don't bring the hard copy bundles that they've been provided with in any event with them to court. So the fact that they don't turn up or do not have access to phones and so forth isn't anything new. Cases can, with a little bit of adaptation and so forth, proceed. I accept entirely the point that Paul has made, that this doing hearings remotely slows things down enormously. But one final clip in relation to my intended trial. I hope the trial doesn't take place, because we've got 3 lay witnesses giving evidence in Albanian via translators. So imagine having to deal with that.
Wow.
Doesn't sound like 5 days to me, Peter. Sounds like 15.
Probably will be, Paul.
I just reflecting really, as I've been hearing other contributions. I think one of the reasons why cases take longer is it is actually very tiring. I was cross-examining the mother for 2 relatively full days, probably a total of about 3.5 hours, spread out with lots of breaks. And by the end of the process each day, I was exhausted, and I'd heard this from others, and I couldn't really, before having gone through it myself, couldn't really sort of identify it. And I think the fact it's so exacting and tiring is part of why the process is so much slower as well, actually. I can confirm from personal experience how tiring the whole process is. Just staring at a screen for hours is, in and of itself, exacting and tiring.
Not only is it tiring for the advocates, but the comments that I've had from other judges, both part-time and full-time, of tribunals and court hearings, is that it's also very tiring from them, and far more tiring than when you deal with a hearing in person.
I've had a message come through on the chat. You may all have seen it. It says, in terms of criminal work, is the Welsh equivalent of liaison and diversion currently working in police stations and courts to identify vulnerabilities that might mean video hearings are not appropriate? I'm not sure if anyone has any comment on that.
I'm not sure if anyone else wants to comment about their experience, but our full inquiry report goes into a lot more detail about liaison and diversion and identifying it, and identifying difficulties at both police stations and further on. I don't think there is the exact equivalent in Wales of liaison and diversion in England, but there are some processes, and our full report, which is going to be published later in the year, goes into a lot of detail about that. So sometimes they are being identified and not always.
Has anybody else got any comments or questions? No? On that note, if Anghar is happy with this, I'd like to thank all the presenters and everybody for organising and taking time to attend. And this video will be shared, so I'll share it out to those that registered. I've got some email addresses from those that haven't. If you'd like to drop me a line, my email address is emma@legalnewswales.com. And obviously continue to join us for more events, and take care, and I'll see you soon.
Sorry, just for me at the end, if anyone wants to read a copy of the interim report, it's on our website, which is equalityhumanrights.com.